This meeting is being recorded.
Muy buenas tardes, buenos días, buenas noches, donde me estén escuchando. Mi nombre es Edgar Rojas, desde Estados Unidos, y una vez más, bienvenidos a otro programa de Conversando con CISOs. Nuestro colega Andrés Almanza no puede estar con nosotros hoy, pero estará con nosotros en el próximo programa. Antes de comenzar la conversación, una conversación muy interesante acerca del sector salud y todas esas cosas, los quiero invitar a todos al evento de CISOs Latam Summit el 5 y 6 de octubre en Santa Marta, para que nos acompañen si pueden, la página tacticaledge.co, y miren a ver quién es la gente que nos van a acompañar, los expertos que vienen a liderar talleres con los CISOs presentes, para que se registren y puedan recibir su invitación. Vamos al inglés. With us we have Jim Sullivan. He comes from TATA Consultancy Services, and Jim and I are colleagues. We both work at TCS. Jim is an expert in healthcare. You've been in healthcare, cybersecurity for how many years?
30 plus years.
30 plus years. Yeah, I will say you're an expert.
either an expert or just wounded a lot. Yes. Definitely a lot of experience.
A lot of blood, a lot of scars. So yeah, exactly. So let's talk about healthcare. And again, even though this program is geared towards Latin America, right? I've noticed in my experience that a lot of the healthcare regulations in Latin America do follow HIPAA, as most of the world, correct?
That's correct. Yeah, HIPAA was established back in the mid-1990s. And it was really a response to making sure that information from a patient's point of view and a member's point of view, if you're speaking from a payer rather than a provider point of view, was secure, so that information would only be used within that patient's continuum of care, whether it be for financial insurance purposes and for clinical medical purposes. So that's where the HIPAA privacy and security statutes, guidelines, that's where it all originated.
Excellent, excellent. And I know last year, I was reading about it, last year, there's a new regulation was proposed, new changes to the HIPAA regulation. I guess is to make it follow more into the privacy type of domain, right?
Yes. Well, one thing to know about HIPAA and what happens with HIPAA is it has evolved over time, and it has progressed. It originally did start out as an approach to protecting the fiscal information for healthcare payer claims. And, that's different from every country. Of course, in the United States, we're a commercial-based multi-payer system, and that does not necessarily translate one-to-one to other countries where it's a single, maybe federal payer system. But, the aspects of privacy and usage really are the same conceptually. And over time, HIPAA has evolved as technology has evolved into health information exchange, electronic data interchange, and the interoperability and the connectivity and the openness in terms of at least sharing that information across the healthcare continuum that's evolved over time. HIPAA has had to adapt and evolve as well to be sure that, not only on paper does the privacy and security of patient information get preserved, but also in that electronic transfer that patient and member privacy and security gets preserved. The integrity of the information is preserved, and that at the end of the day, it's guaranteed that only the people who need to see that information are looking at it, both procedurally and as a matter of process.
And including you as the patient, right? I mean, that's
exactly right. And actually, Ed, you and I, and as folks will understand, you and I are subject to privacy and security, possibly in our given jobs, as consultants, as a company, and as consultants, as individuals serving a client. We need to follow whatever the localized rules are, regardless of what country we're in. We need to be aware of and follow those rules of engagement and those rules of privacy and security as they apply to the client that we're working on in the location and country that we're working in.
You know, that's a good comment, because I know we had this conversation with another CISO a long time ago about how us as professional experts in cybersecurity or anything, that we need to be aware of the regulations. We cannot go, and if we break the regulations and we cannot say, oh, we didn't know.
Right.
Right? So
That's right.
liability, but is that what HIPAA regulation, it's making, like the healthcare organizations make sure that everyone is aware of what, they need to be compliant with? It's that part of our HIPAA?
It is. So as a baseline, and Ed, you've heard me talk about this before, as a baseline in the United States, HIPAA, which is a federal regulation, and you could find it in the code of federal regulations, and these are things that you could easily Google. As part of the federal regulation guidelines, that really is, although it's federally mandated, when you get right down to it, that's also the lowest bar of regulatory issues that we've got to follow, to the point that you and I were both making is, in the United States, it depends on what state we're working in. We've got to follow HIPAA guidelines at their base, but each state also very likely has their own statutory rules and regulations for privacy and security, with PHI, which is protected healthcare information, which is kind of an overall umbrella that also includes PII. So when we're talking telecom and other things, and banking, we might be talking PII, personally protected information, right? But this is personal healthcare protected information, which could include, name, rank, phone number, social security number, and nowadays, to the point that HIPAA evolves, biometrics is involved. It could involve face recognition and things like that as the base format and data elements that are involved in identifying you. And from a regulatory perspective, to our point that we were making, the regulations may and most likely do differ from state to state in terms of, especially in terms of mental health, behavioral health, minor consent, and who can in that continuum of care and who should in that continuum of care have privy to a patient's information. And as a consultant, as the expert in the field, when we're servicing a client, be it a public sector government, federal or state government client, or a commercial client, it's up to us as a consultant to know those localized regulations and guidelines so we could guide our clients. And in the US, we may be dealing with a payer that is a national payer, or a regional payer that has operations in multiple states. It's up to us to realize the nuances and differences and specifics in each state regarding PII and PHI regulations specific to that state, and maybe even specific to a portion of the industry, so we could apply and guide our clients correctly.
You said three things very important that I wrote down, so let's continue the conversation in that one. Quick question: biometrics, that consider PHI?
It does. There is a core data set of PHI that are identified as here are positively identifying data elements, and things like fingerprint, facial recognition. Those are things that are continually evolving and being added into that core data set. So seeing a picture on your license, on your driver's license, or on your medical record. My personal medical record for some of the healthcare organizations that I am a patient of has my picture associated with it, right? So along with my name, along with my address, along with my phone number, along with my driver's license number, along with my social security number, here's my picture. That's also a biometric identifier that could link me to any one of my patient records. Therefore, it is covered under some sort of privacy and security obligation.
Okay, but that's only because this is what I want to make sure that we clarify. It's PHI under healthcare. It's not the
That's
same. Right. It's not the same PHI airport, for example, transportation, right? That's again biometrics. So in there, it will probably be PII, no longer PHI, but it's a different use of the same.
That's right.
Okay. Because otherwise,
that's right. make it clear, you bring up a good point, right? And this is where some of the oversight or overlooking of the types of information that we have to keep track of. Sometimes there is either confusion or an oversight where companies, organizations themselves aren't looking at pieces of information because they may be very familiar with PII, right? But they're not familiar with the term PHI, protected health information. And to your point, there are some overlaps of data elements, right? If you're only looking at an industry where PII is important, there are certain elements of that PII where if it's included with or transferred to a healthcare setting, that is now PHI, but there's also differences in both as well. There's overlap and there's differences. PHI and PII do not equate to each other on a one-to-one basis.
It depends on the.
There are some equivalencies, but they are not equal.
So is that where HITECH comes into play from a healthcare perspective? When you have a healthcare organization with a third party that is not fully healthcare, it's another one. I'm just going to throw an example, right? This company that provides services to state, that capture all the information on the, street lights. I'm just throwing, like, could be a different, but somehow this organization is linked to a healthcare organization for X reason. Is that when HITECH comes in then to identify the type of transmission that is coming in, the type of data that's being exchanged, and then the type of controls that need to be in place?
It's a very, very good point. Very good point. So, as I was saying before, how, HITECH has evolved over time, or has evolved over time. And HITECH was included in the United States. HITECH was included in the ARA Act of 2009, the American Recovery and Reinvestment Act of 2009. HITECH was included in that bill. So it's the HITECH Act of 2009. And HITECH stands for Health Information Technology for Economic and Clinical Health Act. So as you can see in the title, Health Information Technology captures the point that you just said, right? All aspects of health information technology, from portal use, as a user, as a patient, as a stakeholder. Health information technology, what that encompasses from a healthcare perspective for Economic and Clinical Health Act. So to your point, there are elements of HITECH that have evolved and are included in this act specifically that address how we use technology to talk about healthcare, to transact healthcare, right? When we're trading records, when we're trading information, it's very transactional. So the HITECH Act was put in place specifically to expand on what HIPAA needs to cover, but also to be very specific that we get down to some rules and guidance within technology and as it evolves to deal with it economically, to deal with the clinical aspects of it. And that, to your point, that covers several areas. If I'm an employer, I might be dealing in PHI, but as soon as I get my health plan involved and as an employer, now all of a sudden that employer and employee PHI kind of morphs into elements of PHI as well from PII. So yes, the answer to your question is yes, all very important elements of some of the things that HIPAA has evolved to also include HITECH with to keep track of this information.
That's very interesting because that brings us to another more different conversation. From here we can go everywhere, but let's just go in the current landscape of things. Right, we know healthcare. It's one of the industries that's been targeted for ransomware the most. Right.
That's right.
And so HIPAA HITECH, do they come into play as one of the reasons that, have they been modified, let's say, to be able to start dealing more with how to deal with ransomware? Or is ransomware still considered apart from HIPAA and HITECH?
No, if you take again, Googling these things, if you Google to the Office of the National Coordinator of Healthcare Information Technology, ONC, which is part of the Department of Health and Human Services of the U.S. federal government, you'll find articles and approaches that deal with data security for ransomware. So the industry and the governments are definitely involved in this. And, if you keep up with, the news that's trending, healthcare hacking and ransomware on healthcare information has been increasing over the last 5-6 years. And in fact, if I'm not wrong on stating the statistic, it was either the top ransomware attack area over the last year or one of the top several areas of attack of ransomware over the past year and few years has been in healthcare. So it's very much at the forefront of healthcare technology. And I could say not only in the United States, but again, very easily, you can very easily look up instances of where hacks and ransomware attacks have occurred around the globe that involve healthcare. And the nefarious reasoning for why these attacks take place could be very subtle, very abrupt. Sometimes they don't expose themselves until a period of time has elapsed, and the damage that gets done could be exponential over time. So the ability to track, detect, and document this as soon as possible is essential to curbing the problem and correcting a breach or something nefarious after it's happened. So everyone is on high alert to look at these, incidences and cite them as use cases. But they're, again, unfortunately, pretty easy to look up online, very prevalent if you're doing some research on them to look for specific use cases. But as a learning tool, they're very valuable to apply to our situations as consultants and our clients' circumstances in terms of why is it so important that they are very, very proactive to put a deterrent protective system out there to their healthcare information, and why as consultants, it's so vitally and integrally important to our jobs to make sure that we bring that to the forefront for our clients.
Has it been your experience that you noticed healthcare nowadays, from the year till now, been more interested, more focused, investing more in cybersecurity than in the past?
They are, and the reason being is because the cyber breaches are becoming exponentially more expensive to correct, right? So in the past, before technology has advanced us to where we are now, I hate to say that cybersecurity was an afterthought, but it may have not been a forethought, and high on the budget, quite frankly.
Because it's funny, right? Healthcare is an industry that's focused on technology. I mean, and very advanced technology, correct? So, you're just like, they love this, but then protecting it is like
That's right, because the protection end of it could be a significant line on your budget, right? But the ROI for that being a line item on your budget may not come into play unless you have a problem. It's kind of a catch-22 in terms of maybe having solid proof of what the ROI on your investment into privacy and security is. And as I was saying before, once it's a problem, it's a huge problem for a number of reasons. First of all, it's a huge problem because you've been breached or otherwise compromised in some sort of nefarious circumstance. So you've got that issue to begin tracking and dealing with. But if you're in a locale or a country where there's also regulatory compliance attached to that, it could be very, very expensive to start addressing compliance and responses to reporting in terms of accountability and responsibility. It could be very expensive to deal with that after the fact if you haven't been diligent and prudent in how you've prepared for it to hopefully prevent that attack. So the expenses is definitely a lot heavier on the back end, especially if you're unprepared. So I always address this with a client in a worst case scenario especially when it does come up as a point. What is the weakest link in the privacy and security chain of an organization? And can the organization afford, or do they have contingency to deal with this in a worst case scenario? And if not, we have to make sure that the drills and the procedures that they already have in place are updated and current, and make sure we constantly monitor that for doing any gaps in risk mitigation, risk analysis, and try and be as preemptive and predictive and preventative as we can in our business as consultants with our clients.
You mentioned about HIPAA at the federal level, right? Being the, like the, what do you call it, low or entry level. There's something called Hipaa Plus, right?
So the concept, good point. The concept of Hipaa Plus, and this gets to what we were talking about before. Hipaa Plus, and I apply this mostly in a, when I'm dealing with different states, you know, in the US. The concept of Hipaa Plus means, okay, you've got the federal HIPAA regulations as your base guideline, right? But as I said before, each state may have its own statute regulations that are put in place as a law for that state. And for the most part, you may see it being applied to mental and behavioral health and various aspects of public health that is kind of monitored, if you will, by the state government. So Hipaa Plus means any regulations that are in place either locally or even inside an industry specific segment of healthcare that go over and above what the HIPAA regulations state in the Code of Federal Regulations, right? And again, it's very important to understand that that has significance locally, whether it's state by state, region by region, or potentially even, you know, even within an industry, within a specific vertical industry, be it lab, pharmaceutical, provider, payer, within the healthcare industry. We always need to be on the lookout for specific guidance that may be regulatory compliance issues. It may simply be industry best practices, and it involves privacy and security. Again, it's important that we know that as consultants, and it's important that we make the client aware of that if they're not already, but can also service their needs in that regard. So Hipaa Plus is, to me, everything that's over and above the baseline federal regulations of HIPAA, paying attention to that on a state by state, regional by regional basis, and within the industry.
Okay, interesting. So in the States, we have an issue, like you mentioned before, right? The different privacy that each state, California, I think it's in North Carolina that has their own one as well. A lot of states are coming up with their own.
Most states do.
Already.
They were ones that came up in conversation before, but yes, most states do have their own statutory regulations over and above HIPAA.
So at what point do you think that it's going to be, you know, one privacy rule like GDPR for the states to blanket, because this is making it too complicated?
Well, yes, it is complicated, but it's also purposeful, right? So to your point, HIPAA and HITECH will be that one approach, right, from a federal perspective. But again, the states do take their own initiatives based on what's happening within their own state, what's happening legally within the industry within their own states, and how they see fit dealing with it, which is it's just really part of the game, so to speak. It's part of dealing with the industry on a whole, but in the model that we use and that we have in the U.S., we need to be sensitive and on top of this on a state by state basis. And like I said, once you go out of the United States, these rules and regulations, although mechanically, as I like to refer to it as, in terms of how do we protect health information from a technology and process point of view, there's definitely a lot of similarities in that whole aspect mechanically, but the rules and regulations from a governmental compliant perspective are going to different and be vary. And that's where the United States and how HIPAA is applied in the United States, you know, is definitely nuanced and different than you'll see in other regions around the world.
Okay. And from a non-meeting regulatory compliance in the states with HIPAA, will these organizations then get fined? Is the fines pretty significant that they're like, you know what, they need to invest?
They are, or they can be, let's put it that way. You know, there are mistakes, there are procedural mistakes, and data is inadvertently exposed, but there may not be anything nefarious of it more than a procedural error. You know, something as simple as somebody leaves a patient chart laying on the counter in a doctor's office where I come up to register, and I'm walking into the office and I happen to see
it all the time.
Right, and you do, and you know that's not necessarily an issue unless somebody says, ooh, I just saw Joe Smith's records, and I start discussing it with the next patient, in the waiting room, really in my doctor's office. Procedurally, that's an issue that has to be dealt with. And the organization is really obligated to police their own procedures. And if there is any type of inadvertent exposure, it's usually a very, very small issue, and it's usually handled very locally, very much within that organization, and they just clean up their procedures. If it's a bigger breach, and still not nefarious, but by some mistake, by some accidental process, maybe 500 records are sent to the wrong location. That's exposing the records incorrectly. So there has to be a procedure to document that, inform the people that are involved that the records may have inadvertently be exposed, but also that organization and organizations involved have to be prepared to make the corrections necessary to get, number one, get that under control, and correct anything that may have happened, right? And that's all documentation that goes back to the government within HIPAA regulations, right? It's very clearly spelled out how mitigation procedures have to happen. Now, if there is something that is either significantly non-compliant, or the corrective actions were never really taken or never really handled competently, or it gets more nefarious than that, there is absolutely very clear regulatory guidance that says, if you don't do this, if you do not comply with this, there could be significant fines, and there could also be jail time, quite frankly. So yeah, the retribution and the consequences of not following HIPAA privacy and security guidance and above on the state level could be significant, both monetarily and up to and including being incarcerated.
It's interesting. HIPAA has to do with privacy, and in cybersecurity, we're just a couple of years we're starting to see, the privacy. It's little by little encroaching into the cybersecurity side. And nowadays, we already, when we say privacy, it includes security. So it seems like when HIPAA was created or designed, was more thinking from the privacy, and somehow cybersecurity has taken over as the owner of HIPAA, when it wasn't designed with cybersecurity in mind in those days, it seems.
And the points around cyber security, and put cyber in quotes for a moment, back in the early days of HIPAA, and in fact still now, things like fax transmissions.
Yeah.
That's, even though we're dealing in paper and simple telephonic transmission of records, that's still covered under HIPAA. So there are security procedures that come into play for simply monitoring your fax machine. And I, for example, I'll give you a use case of where something may happen inadvertent, and this is an actual use case, but names have been withheld to protect the innocent, right? So in the lab business, I spent a good deal of time in the lab business where, results are transmitted, orders and results are transmitted between doctors and labs and copied to different labs. So let's say you go to your primary care physician, and this could apply to any country, quite frankly. You go to your primary care physician, and that physician orders a lab test. So that physician might also be involved with a specialist or multiple specialists involved in treating your condition. So as part of that lab order, that physician may say, please copy these results to physicians A, B, and C, or organizations A, B, and C, whatever the case may be. From the lab perspective, if those lab results are transmitted, even in something as simple by fax, let's say somebody mistypes a phone number of a fax machine, and it goes to a fax machine of another organization, which has happened.
Yes, of course. That
fax machine could be receiving somebody's lab results inadvertently for as long as it takes for them to recognize it. That's a breach, right? That's an inadvertent exposure of somebody's private healthcare information. That has to be noted. It has to be corrected. It has to be documented, and people have to be notified about it. So that was the types of things that, even when HIPAA was instituted, and still today, could still even happen. Now, as you know, again, going back to our conversation again, as technology evolves, the areas of security. So privacy is who gets to see your information and why, and who I decide as a patient. Who I decide as a patient gets to see my information. Is it my PCP and my specialist? Is it my PCP and my specialist and one or more members of my family? I could designate that as well. That's the privacy aspect of it. The security aspect of it is at every technology or process, procedural connection point along the way, how does that information get transmitted on a transactional basis, and who has access to it at those points of contact? Can somebody nefariously break in and have access at a particular contact point? Absolutely. That's part of the security issues around that. So privacy issues is who can see my information, and as a patient, who do I decide can see my information? And from the security aspect, who can get your information, who can access your information, and who shouldn't. And you know, one of the things I'll go back to too, this is an initial aspect of HIPAA. HIPAA is the Health Information Portability and Affordability Act, right? That P in the middle of HIPAA stands for portability, not privacy.
Exactly.
But privacy is built into that. Many people think the P in HIPAA is privacy. It stands for portability. So this goes back to the point, we're not trying to build fences and barbed wire around our healthcare. We are trying to protect it. We do need it to be private, and we do need it to be secure. But HIPAA is designed to give you the right groundwork and the right basis for sharing your information, making it portable in the right way and to the right people.
Right. Yeah. So that's why sometimes you see Hipaa with two P's, right?
That's right.
Anyway, Jim, thank you so much. We run out of time here. Fantastic. We could have gone talking now about privacy and about transparency and about the right to forget and all this stuff and how that's going to apply to healthcare. That's going to be very interesting in the future, because right to forget goes against historical, healthcare information. But that's another conversation. So Jim, thank you so much for being here. Really appreciate your.
Absolutely, Ed. And thanks for having me. And hopefully, you know, this was very, very good, by the way, very conversational, and hopefully this opens up some ideas for some people that are watching your podcast and some questions that they may send in. And, you know, hopefully it spawns, you know, another conversation that we may have.
As I said, this can go into the privacy realm, and it's going to be interesting. Jim, thank you so much. Looking forward to continue working with you.
Same here, Ed. Thanks for having me. Appreciate it.
Bye-bye. See you later.